Now, with a quick reaction on this piece of news, Suhel, this is pretty much on expected lines. I think the bigger news would have been if the judgment went in the favor of Cyrus Mistry, but I think the street was largely working with the assumption that it would tilt in the favor of Tata Sons. Your reaction?
Well, I said this on your channel on October 24, 2016, the day Cyrus was removed as chairman of Tata Sons, saying when battles are fought between values and valuation, values always prevail. Today's judgment is about the prevalence of those values. It's about the fact that no matter what insinuations you make, no matter what abuse you hurl, no matter what innuendos you indulge in, ultimately truth will prevail. There have been so many rumors, so much of street gossip, so much of talk, but ultimately, Aisha, what really happens in the world is people separate the wheat from the chaff, the truth from deceit, and manipulation from absolute care for values. Today is not a victory for Tatas. It is a reiteration of the belief that the justice system, that the people of India, consumers, shareholders, media, all have in brand Tata and what brand Tata really means for not just who they touch, but who they help, who they serve. These allegations made against the trusts, against an honorable person like Venkat, against people across the spectrum, these were, to my mind, despicable displays of desperation. The 3Ds, despicable displays of desperation. Cyrus, I hope, will be wiser to just recognize one thing. He too sat in that chair for 4 years. He owes a debt of gratitude to the House of Tata, both as a past chairman and as a shareholder. So I hope this battle will be put to rest. People need to work. People need to move on with their lives. People need to be unencumbered with allegations which are pure malicious drivel. And to that end, I'm deeply, deeply satisfied with the verdict. Not just satisfied, I'm delighted that in this country, no matter when everything falls apart, we can stand and lean on the pillars of justice, because justice, to my mind, in this country is still prevalent and still recognizes the truth.
We'll just hang in there. I've also got on board with me Prabal Basu, management advisor and former corporate director as well, joining in. And we also have Anil Singhvi. Anil Singhvi, if I could get you into this discussion, would you say it's a fair judgment that it's victory Tata Sons?
I don't think we have heard the final word on the subject. I think it will go through the appellate tribunal and Supreme Court. So one has seen enough times of NCLT judgments completely dismissed at appellate tribunal level or at Supreme Court. And I think these are the things which India or Indian corporate law for the first time is testing it. So there are not many precedences to draw upon whether Cyrus was right or whether Tata Sons was right on that. So I think we haven't heard the final word as yet. I think it has to go through more tests of the, and again, it's not just the fact. There are a lot of law issues which are there on that, how to conduct and how to govern and how the corporate India should really be looking at corporate deliberations and the outcome of those corporate deliberations. So I think it will be a very interesting case to follow till such time a Supreme Court pronouncement comes in the way. So I'm not onto one way or the other, whether happy or otherwise, on this of NCLT's first hearing. It's like a trial court giving a predicament on any of the larger issues in life. So I think one has to wait and watch how it develops into at a tribunal level, appellate tribunal level, and then after in Supreme Court.
Would you believe that this is not it? Like Anil is saying, that Mistry has other options at hand. He can go along to higher courts and, put in a plea over there. Do you sense that this long mudslinging battle doesn't end here with the NCLT dismissing Cyrus Mistry's plea? Mr. Roy, can you hear me?
Yes, I can hear you. Okay, all right. Sorry, I didn't realize this question was for me.
Yeah,
you see, this was by far the most high-profile case of oppression and mismanagement. under Section 397/98 and of the earlier Act, and now under 241/46 of the of the new Act. The trouble is, it is difficult to prove or act under these sections, even for a high-profile minority investor like Cyrus Mistry. And the reasons are threefold. I mean, it's obvious, but I'll just state it. Because firstly, the jurisdiction of these sections cannot be invoked unless there's the involvement of malice or malfeasance. Now, this is difficult to prove, right? Number one. Number two, the courts have held that unwise, inefficient, or careless conduct, these are court's words, of a director is not enough grounds for oppression. And thirdly, of course, the cardinal principle of invoking this section, any case, has been that it's not meant to interfere with the day-to-day functioning of the company unless there's a manner prejudicial to the company's interest, or to public interest. So because of these three things, it's very difficult to prove or act under these sections, and entrenched management in India, whether it's Tatas or not, is not relevant here. Any entrenched management is very difficult to change. So I'm not surprised at this judgment. I'm not going to give a comment whether I'm happy or not, because like Mr. Singhvi said, the last has not been heard on this. It will go right up to the Supreme Court through the appellate process. And it's a very, very interesting case for those who follow corporate governance, who are involved with corporates, to understand, because the issues which Cyrus raised are pretty fundamental. Pretty fundamental. So that's where I would leave it at the moment.
In fact, my colleague Ashwin Mohan had just highlighted that the next stop would be the NCLT, and like you pointed out, there are higher courts to knock at, and this is a matter of reputation, so I don't think Mr. Mistry and his team would give in that easily with this verdict. But Sriram, coming to you, how do you see this story unfolding? Because in the statement or the decision laid out by the NCLT, it's been a complete clean chit for the Tata Sons. They have said Mistry openly went against board and directors. These are some of the details of the statement and the judgment rather. Have found no merit in legacy issues raised by Mistry. Do not agree that Ratan Tata conduct was prejudicial to the company. Do not agree that Ratan Tata acted as a shadow director. Management is more accountable to shareholders under the present regime. So it's been completely advantage Tata Sons if you look at the details of the announcement. Your take?
Yeah, definitely it's a short-term setback to the Cyrus Mistry's case, and obviously NCLT has viewed at each of the allegations in detail, and some of these relate to the business of the operating companies, and so NCLT has ruled that they have to defer to the business decisions and they wouldn't like to interfere. And as Prabal said, one has to observe or differentiate between oppression and mismanagement, which are two different things. And unfortunately, our Companies Act, which will evolve probably over a period of time, has to segregate between oppression of minority shareholders and mismanagement of the business itself. So when minority shareholders make this allegation, as Cyrus Mistry said, I guess the courts would be find it very difficult to differentiate between oppression and mismanagement, because some of these issues, like converting the public limited company to a private limited company, which happened after Cyrus was removed from the board, is definitely an oppression, can be viewed as oppression. But the operating decisions is mismanagement, and that the court probably rightly said that it is up to each of the boards of the operating company. So one has to differentiate amongst all these issues, and each one has to be dealt in a different manner, each of these issues. But as the other speaker said, we have not heard the last of this, and it will go all the way till the Supreme Court.
And in fact, my colleague Ashwin Mohan, who's been tracking the story from the word go, joins in with a deeper analysis of the statement that's been issued. Ashwin, we have a power-packed panel over here analyzing the judgment, and this is really a landmark one, but not the last on this matter.
That's right. This is the big breaking news coming in from the National Company Law Tribunal in Mumbai. It's a complete washout as far as the pleas and arguments of Cyrus Mistry, against Tata Sons, Ratan Tata and the Tata Board of Directors are concerned in this 2-year boardroom tussle, which was keenly watched by entire India Inc. Now, this order is extremely important because this order will also set a precedent as far as the entire Companies Act is concerned and as far as the relationship between the board and the executive chairman is concerned. The plea has been dismissed, which means that Cyrus's allegations of oppression of minority shareholders by Tata Sons fall flat. Let's not forget that he does have an option, of course, to challenge this order at an earlier forum. But the most important aspect in this entire order is the fact that the board, or the NCLT in fact, has ruled that the board is well within its rights to remove the chairman. Therefore, they feel there was no illegality in the sacking of Cyrus Mistry as chairman, which is one of the major grounds raised in the plea. In fact, to throw more light on this particular aspect, let's take this conversation forward. Joining us is, of course, a whole host of experts on this issue. Joining us, of course, is now Mr. Sriram Subramaniam. Mr. Subramaniam, what do you make of the aspect that the NCLT has not found anything wrong with the manner in which the board of directors sacked Cyrus Mistry? That's not all. They have not found any interference by Ratan Tata as well, which Cyrus claimed was prejudicial to the interests of the shareholders. Your take, sir?
No, definitely the board is within its rights to remove Cyrus Mistry on any day. But the manner in which, because one of the things said that there has to be a 15-day notice to table any agenda item at the Tata Sons board was, I guess, not provided. And the fact is that even a few months before, the board of directors had sort of done a performance evaluation and given found nothing amiss. So within a couple of months, you are saying that his performance doesn't merit justice and he's removed. So that is what I think other investors would view as injustice to Cyrus Mistry. But whether the directors or any board has the rights to remove the chairman, executive chairman, yes. I mean, they are well within their rights. But whether they did it in the right manner is the question here. And
Right. Right, Mr. Subramaniam, hold on to your thoughts. Mr. Suhel Seth and others as well. Mr. Parekh as well, hold on to your thoughts. I have with me on location Somaseka Sundareshan, who appeared on behalf of Cyrus Mistry at the NCLT. The order has gone against Cyrus Mistry. On all counts, the plea has in fact been struck down by the NCLT. What's your next course of action? You can of course move at the higher forum, which is the NCLT.
For our side, this has always been a question of having the governance principles laid down. We'll need to wait to see the order for the minute detail, but most certainly we'll be pursuing our view of what constitutes good governance in appeal. There is a statutory appeal that's permitted in law, and we intend pursuing it. Of course, we will see the order for the form of the appeal, but in substance, we will certainly be appealing.
So we don't have the full fine print of the order as yet. This is just the operational part of the verdict, which was read out by the bench a short while back. But on all the counts, whether it was the alleged interference by Mr. Ratan Tata, whether it was the manner in which Cyrus was sacked as a chairman, whether there was any mismanagement. In fact, the bench has also gone on to say that the current regime, the shareholders are better served. So on all counts, it does look like the bench has favored the Tatas. So on that point of view, what do you have to say? There clearly doesn't seem to be any relief because you sought multiple reliefs.
If the dismissal is on all counts, the appeal would be on all counts. So we'll pursue the appeal. For us, this has never been a battle of ego or a fight between two individuals. If you see the reliefs prayed for, this is something clearly that we believe the reliefs we sought are necessary for good governance. If we've lost on all counts here, there would be an appeal on all counts as well. So this is something that would have to be judicially determined at two more layers of appeal. So whichever side wins or loses in a matter like this, you must assume it's going to go the whole hog all the way down the path.
So one last question before I let you go. How important is this verdict from the impact of the Companies Act and also as far as corporate democracy is concerned? There were several interesting questions raised by the Cyrus Mistry camp.
Well, it's an important matter, which is why it will go into appeal. The judges have expressed their mind quite openly today. Let's wait for the order. It will be very difficult to comment about what we believe is right or wrong with the order. These are matters to be agitated in the courtroom and not in the media. So we'll deal with it in appeal.
All right, so deal with that and also deal with the weather as we all get soaked here outside the NCLT in Mumbai. So there you heard it, speaking exclusively to ET now, Somaseka Sundaresan, the counsel for Cyrus Mistry. On that note, let me also get in Mr. Suhel Seth into this conversation. Mr. Seth, Cyrus Mistry's camp had waged this battle as a battle for transparency, as a battle for corporate democracy. Big setback for them, right?
You know, you've raised a very important point, and I just want to address 4 quick things which the verdict spells out. Number 1, they said that the board of directors is the competent authority to remove the chairman. Number 2, they said Cyrus's removal was because of his acrimonious behavior in the board. Number 3, they mentioned that Ratan Tata and Soonawala had nothing to do within the ambit of 241 and 242. Number 4, and that is a very critical issue, they found no merit in the legacy issues. You know, it's not about a just judicial setback. It's about a perceptual setback. What was happening over the last 2 years is you were throwing mud at a venerable 150-year-old institution, hoping it would stick. You took to the media, you took to other forms of, mudslinging. It didn't work. You went to courtrooms where finally at one level, obviously, Anil Singhvi and Mr. Roy said, it isn't the last. We obviously know it isn't the last, but we're having this program today. We're not having it in 2022. So I have to comment on what's happened today. I can't tell you what the future is. I'm not Nostradamus yet. Having said that, the critical issue is it is both a judicial as well as a perceptual setback. But for me, I always look at the glass half full. For me, it does 3 things. It continues to vest my hope in India's justice system. Number 2, it continues to suggest that the Tatas behaved and continue to behave ethically. In fact, there's a point in the verdict where he says that Ratan Tata's conduct was never prejudicial. He never attended a board meeting. He never went to Bombay House after 2012. And the third final point is that, yes, it is one step and there will be many that Cyrus will and can take. He's entitled to as a citizen, as an aggrieved party. But the reality is, today, if you look, and ET now tracks the markets more than anyone else does.
So your first reaction?
See, the petition has been dismissed in toto, but we'll have to see the reasoned judgment. But all the allegations put forth, when they read out the judgment, appears to have been dismissed.
Sir, just one thing. How do you see this because this is also a test case for companies law, and clearly a lot of the issues when it comes to interference by Ratan Tata, so on and so forth, had been dismissed. How do you see from the larger perspective?
See, each case depends upon facts. And this case also essentially being a case of oppression and mismanagement, the court obviously has examined all the factual issues and has also examined the provisions of corporate governance under the 2013 Act and has given very detailed reasons.
So my last question, we all know clearly this is one of the most bitterly fought cases, and particularly how the Tata Group functions. Clearly this will be a big vindication for the whole of Tata Group, because Tata Group has never seen such acrimonious battle in its existence of 150 years.
Yeah, this is one step forward, no? Let us wait and see.
Okay. Thanks a lot, sir.
Thank you.
Yeah, so there you have it. ET now continuing with its breaking news comprehensive coverage. Both the councils of the Tata camp as well as the Mistry camp speaking first and exclusively to ET now, minutes after the verdict. Let me take this discussion forward and get in another lawyer who's been waiting by rather patiently, Mr. Sandeep Parekh. As Mr. Suhel Seth was pointing out, eloquent as always, he also mentioned the fact that one of the major takeaways from the judgment today was the bench was unequivocal. They clearly made it very, very clear that Mr. Ratan Tata had in no manner behaved as a shadow director, as was in fact alleged by the Cyrus Mistry camp, and in no way were any of his actions prejudicial to the interests of the shareholders. Now, this is a very important takeaway, because at the end of the day, Cyrus Mistry was always highlighting the relationship between Tata Trust, Tata Sons and the operating companies. Are you hopeful that perhaps there will be a law laid down in the fine print of the judgment as far as the relationship between holding companies and group companies are concerned, Sandeep?
Again, if the order had gone in favor of Cyrus Mistry, I think we would have seen some jurisprudence. But the fact that it went against him does seem to indicate that there may not be much jurisprudence on those counts. But I think the bigger picture is still not decided in this specific court, really. I think if you look at the listed companies, if you look at the Air Asia incident, various issues which are being investigated by various agencies, I think the bigger picture is still out there, and the breach of fiduciary duty and corporate governance issues are kind of a much smaller part of that picture. So I think that will still develop on its own steam, independent of this particular outcome, whether it will certainly go up in appeal, as the counsel said. But I think this is being fought at very many forums, and all of those forums will kind of have to stick to their own facts and come to their own conclusions. So let's see how it goes. It's too early for the Tatas to really declare victory.
Right. So Sandeep Parekh says it's too early to celebrate. Mr. Subramaniam, what message does this verdict send to India Inc.? This is the representative of the single largest shareholder in India's biggest conglomerate, who had waged a publicly fought war, a very bitter war against India's oldest conglomerate and the Tata Sons, as well as the board of directors and plus Ratan Tata as well. Today he stands defeated, but of course he does have the recourse of appealing this at a higher forum. But what's the big takeaway here as far as India Inc. is concerned? Because rarely have we seen publicly a boardroom battle being fought like the Cyrus Mistry versus Tata Sons one.
Definitely, this is a marquee case in that sense of a very significant minority shareholder in a largest holding company is sort of aggrieved. And so from that perspective, whether the courts went just by the names or whether the courts went by very fundamental principles, that needs to be seen. As Sandeep said, the external manifestations of some of these are the investigations or the actual behavior. Last month, Tata Motors produced one nano car, okay, in June 2018. So that sort of gives credence to some of the allegations which are made. And two is the relationship between the holding companies and the operating companies also gets defined. And many business groups in India have these structures. And that's where, in fact, SEBI came out with a sort of a guideline last year. And of these, of actually a set of individuals being allowed to privileged information. And so I think this is a nuance which corporate India will undergo, where a promoter sort of exerts influence through not just the holding company, all the way to the operating company while not being on the board. And I think increasingly that will get challenged, or that will get much more evolved, because as families move out of management, as promoter families move out of boards, they will yet continue to exert influence. And that influence may not be directly visible. And that's where I think corporate law has to undergo some more refinement to arrive at some solutions.
Right. Let me also rope in Prabal Roy, who's been waiting by rather patiently. Mr. Roy, after the ouster of Cyrus Mistry as Tata Group chairman, the Tata Group took some time to gather things, to get back on track. They elected N. Chandra, who has now completed more than a year at the helm of affairs at the top. So stability, so to say, has returned at the Tata Group, because Chandra has indulged in a cleanup act of sorts and is trying to, in fact, maximize profits and get back some of the Tata Group companies to their leadership position. But do you think this order or the pending, or the pendency of this case was proving to be an overhang on some of the Tata Group stocks? Now that the NCLT has ruled clearly in favor of the Tatas, you don't have that overhang anymore as far as the operating companies are concerned, because may not be the retail investor, but foreign institutional investors do take such matters very seriously when investing?
Well, being from both the corporate world as well as an active player in the financial markets through the fund, I can say with a fair degree of confidence that this particular order does not take away the overhang from the stock. The overhang on the stock are for various other reasons, which I've written about publicly elsewhere. And that's to do with the performance and the way the strategy is being implemented for various reasons. So this particular incident will not do anything to remove the overhang of the stock. But let's just step back for a moment and see what was the larger issue Mistry was fighting for in this. There were essentially two in my mind. One was that the board is accountable to the minority shareholders for governance on one hand and management performance on the other. This was one. And the second was for fighting, and this is written in his appeal, he's fighting for the protection of the Tata institution as such, both the governance and the integrity part of it. Now, I'm not sure whether NCLT is the right forum for this, frankly. I mean, because they will, go more by the law and the strict interpretation of the law. For example, we just heard a comment here saying that, Ratan Tata did not interfere because he didn't attend any board meetings. Obviously, those of us who have been on boards know these things don't happen like that. The way it happens is a phone call comes, right? And that is how, so he need not be physically present and his or her will is implemented. So let's not get into all that. My basic point is it is nobody's case, including mine, and I have written about this again publicly. It is nobody's case that the destruction of shareholder value in some companies during Ratan Tata's time was a consequence of dubious intentions like a Vijay Mallya, etc. That has never been the case. But it is surely a case of, let's say, repeated instances of poor judgment and a flamboyant management style. Now, unfortunately, that was laced in a corporate culture within the Tatas,
right,
in which Ratan Tata's decisions were above
Mr. Roy,
critical questioning, right? And anyone was, so this does not fall within the purview of the NCLT, frankly. So to ask your question about the overhang on the stock, that will remain. I mean, till
all right.
all these things.
All right, Mr. Roy, I get your point.
Out.
All right. Okay, so Mr. Roy is of the opinion that the overhang on the stock remains, and there are several questions raised by the Mistry camp which perhaps the NCLT may not be able to answer. Maybe those answers are best given by other forums. Sandeep Parekh, one of the other takeaways from this judgment is that the NCLT was of the opinion that Cyrus Mistry openly went against Tata Sons and the Tata Trust, and that in their opinion was perhaps behavior that was unbecoming of a chairman. Let's not forget that there was a letter that was shot out to Tata Sons, and that letter spoke about how many of the Tata Group companies were bleeding. And after that letter, we saw a steep crash in the stocks of all the Tata Group companies. At the end of the day, Sandeep, do you think perhaps that was something that Cyrus should have done, knowing very well the consequences, because all of these are listed companies?
I think you kind of hit the nail on the head. I think that's really the crux of the whole issue. And I think this whole thing really started after a very long piece by The Economist on the Tata Group. I think the major issues related to investments, there were many investments made which were duds. And I think Cyrus was trying to clean them up, but they were kind of prestige projects for Ratan Tata. I think that's probably the origin of the conflict. But I think what is also on record is that he was given full marks, almost 100% marks at the evaluation just a few months, 3-4 months before he was thrown out. New members of the board were packed in who judged his performance. So, I mean, very, very dubious things have occurred in those 3 months. For NCLT to give a complete clean chit to Tata's doesn't seem like they've not kind of again, it's subject to reading the actual order, but it doesn't kind of flow from it's not a sequitur from the other. So let's see the terms of the order. Let's see kind of what are the governance issues, corporate governance issues which they've addressed, and whether this kind of an action, throwing out an independent director like Mistry Wadia, suddenly again based on completely opposite stands they'd taken just a few months back. So I think all these things will have to be seen, and almost 100% this will be appealed. So we'll probably, I think, hear the final word not even from NCLT, but this will go to the Supreme Court at some point.
Right, Sandeep. Let me now take the conversation forward and get in a few additional comments from Suhel Seth. Mr. Seth, one of the other allegations that was also raised by the Cyrus Mistry camp was that there was a violation of insider trading norms. Essentially, he was trying to say that there was information floating from the group companies to Tata Sons to perhaps members of the trust, and members of the trust had no business knowing this information before it was released to the public. Now that the NCLT has ruled that Ratan Tata and Mr. Soonawala were not acting as shadow directors and did not do anything against the interests of the stakeholders, do you believe that those allegations also stand buried now?
Here's the thing, and let's just be logical. Number one, I don't follow the stock market. I don't even have a demat account, so I'm the last person to even know about all this thing. But let me just make two logical points. Number one, Ratan Tata and Soonawala's credibility and credentials are impeccable, and they can't be, bandied about in the way Cyrus attempted to bandy them about. Number two, Cyrus was chairman for 4 years. From 2012 to 2016, the Garden of Eden was filled and blossoming. And on October 24, the Garden of Eden turned into the Garden of Destruction. You were fine with all the value so-called allegations that you made earlier. Nothing had happened then. It was all rosy because you were occupying the chair. So the day I remove you as a journalist from ET Now, will you start bitching about your channel? Will you say ET Now is not honorable? And if you do, will your credentials and credibility not be suspect and under question? The answer is yes. Number two, insider trading, allegations of impropriety, interference have all been addressed in this judgment. Our four of us television, heads, talking heads, the competent people know. There have been documents that have been supplied to the NCLT. There have been representations that have been made by some of the finest legal minds in the country on both sides. To be fair, on Cyrus's side and on the Tata side. So now to say, that this Garden of Eden was filled with weed, to my mind, is preposterous. It is an allegation that was attempted only so that it could stick. Look, a lot of people on your program, including one gentleman, said, there's a flamboyant style of management. The NCLT is not going to get into what sartorial elegance directors of companies, use. It's a limited case of law. And on those 5 points, as you have rightly said in your opening remarks post the verdict, those 5 points have been addressed by the court. Both Somashekharan and Mr. Parasaran have said that they need to go into the details of the judgment, which they will. And of course, if there is an appeal will happen. The reality is that the train which was carrying all this mud, attempting to sling it, has halted briefly. We now need to know what the next steps are. My initial point made on your program, both on October 24 and today, July 9, remains the same. Values always prevail. Truth always prevails. You can have an interim period of dissipation, of disgust, of despicable desperation, but ultimately it will all fall asunder, which we have seen. Yes, there will be an appeal. There is going to be an appeal.
Right.
We don't know what Cyrus's plans are, but that's the reality.
Mr. Seth, values and traditions, of course, always continue. But we are discussing a judicial verdict, so let's not forget that the rule of law also, at the end of the day, will prevail, and we'll have to wait and watch to see what the next move of the Mistry camp is. Sandeep, let me get you in over here. I think many of us have been speaking about the one aspect, and this is something that was highlighted continuously by the Tata Group during the course of many of the courtroom proceedings that I personally covered. Their point is, why did Cyrus make these allegations in hindsight? Are you convinced that perhaps if Cyrus had raised any of these corporate governance issues during his term as chairman, then maybe there would have been more solid legal grounds? Because at the end of the day, he's made all these arguments and accusations in hindsight, and many believe that's what has weakened his case.
No, sir. From what I understand, which from the facts which are available in public domain, I think it's very clear that friction had started long before. And as I said, I think the Economist piece kind of brought out those tensions. So it was about kind of whether you want to hang on to the Tata Nano, for example, and though that's not the crux of this litigation. But I think it's the frictions had started long before the boardroom battle started. I think the battle was in fact just very short. It was just 2-3 months old. Essentially, the trust with its very large shareholding could fill the boardroom with new people who judged the chairman of the board for the past 5 years and threw him out. So it was obviously quite pretty bizarre. But certainly, I think it's kind of tough to explain it by saying that everything happened in kind of a period of 1 or 2 months. So certainly tensions must have been simmering for some time, and the battle really lasted 2 or 3 months. And with the shareholding with the Tata Trust, I think it was a foregone conclusion that they throw out the people who would disagree with them.
Right. So clearly, I mean, Sandeep Parekh is saying that there's more to it than meets the eye, but we, of course, can only comment on deliberations and arguments that we heard and observed during courtroom proceedings. On that note, I must thank all my guests, Prabal Roy, Sriram Subramaniam, Suhel Seth, as well as Sandeep Parekh, for taking out time and helping us dissect the impact of this big verdict that has come in today from the NCLT Mumbai. Clearly, it's a huge victory for the Tatas, but like they all say, it's not over till the fat lady sings. Cyrus Mistry does have an option to challenge this order at a higher forum, which is the NCLT. On that note, we'll wrap up our special breaking news coverage. Stay tuned to ET Now for more news and updates.